haven't checked the mail yet, did you?
No. Good morning. This is Deb Van Dyke-Reese, the Director of the Nebraska Court Improvement Project. Thank you so much for joining us for the webinar, Juvenile Records, How Records Can Affect You Even After the Case is Over. And so I am thrilled to have Serena and Ari here to do the presentation today, but I did want to do a few housekeeping items first of all. Just to let you know, we are recording this webinar and it will be available on our YouTube channel in a few weeks, so we will send out a link to that once it is up and available for viewing. And I also wanted to just do a quick plug for our regional conferences that are coming up October 3rd in Omaha and October 4th in North Platte. At this time, our regional conference in Omaha is full, but there are some spaces available for the North Platte Regional Conference in October on the 4th. And one last thing, I did want to make sure that you *6 or mute your phone so we can make sure that there's no feedback. So with that, I'm going to turn it over to Serena and Ari.
Hi, everybody. My name is Serena Holthe. I'm with the National Juvenile Defender Center in Washington, D.C.
And I'm Ari Crum. I'm with Legal Aid of Nebraska.
And we are working together on a project funded by the Office of Juvenile Justice and Delinquency Prevention, where the NJDC has sponsored a fellowship program, and Ari is one of our fellows, and she has focused her work on helping young people who have been in the juvenile justice system overcome some of the obstacles that they face as they're reentering their communities. And we have done a lot of research on this issue. Ari has done a lot of research on this issue, and together we have wanted to make sure that this information gets out for everybody to understand that juvenile records, especially in the state of Nebraska, affect a youth well after the case is over. Thank you. So as many of you might know, there are many common misunderstandings when it comes to juvenile records. Most young people believe that their juvenile record will just disappear when they turn 18. As you can see on the top right, I totally forgot to do this question first. But the answer here is true, that everywhere I've gone, and I've traveled throughout the United States talking with people about collateral consequences of juvenile adjudications, and generally everybody believes that mostly young people, but even people in position of power, so correctional officers and other folks tend to believe that juvenile records just disappear, they don't have any effect on a youth after their case is over. So let me not miss the next poll question that we created. Nebraska is one of blank states that make all juvenile records available to the public. You should see the poll at the top of your screen, and you can enter your answer, and we'll be able to broadcast the results for everybody to see what the answer might be. Okay, well, it looks like the majority of you are correct. It's actually one of only 6 states that'll make all juvenile records available to the public. Most states don't have such availability of their juvenile records. Now, our next question is a true or false question. Sealing means the record is destroyed. And is that correct or is that false? And these polls actually really give us a good idea of where everyone's at with their understanding about the consequences of juvenile adjudications in Nebraska. And you guys are correct. 34 of you picked false, and that is correct. So sealing does not technically mean that the record is completely destroyed. Some states, sealing might go that far, but just not here in Nebraska. The common misunderstandings around juvenile adjudications also include a young person often believes that I won't have to tell anyone about my juvenile record. It's never going to come up, and no one will ever find out about it. These are things that people, especially in Nebraska, believe, but they definitely, we've heard these from people throughout the country. But collateral consequences of juvenile adjudications in Nebraska are different than in other states just because of what we talked about earlier, that juvenile records are generally available to the public. Now, this is an issue for young people because, number one, we all, as we just said, is that most people believe that juvenile adjudications don't have repercussions, that they just go away, there's no big deal about it. However, they do have repercussions, especially in Nebraska, because anyone can find out about a juvenile adjudication. These young people, they're going through a period of life where their brains are still developing. They are trying to figure out what's the next thing I'm supposed to be doing and how can I move on with my life. And all of a sudden, they realize that what I did a few years ago is now going to affect whether or not I can get a job now. It can affect whether I can get into this apartment. Many things coming down the pike can be affected by it. And so we need to make sure that as we think about a young person who's going through the system on the front end of the matter, before they even have a record, is this someone who really needs to have something on a permanent record that could show up for everyone in the community to see? I mean, our juvenile justice systems were created to allow there to be a different process for young people, a different system, because we recognize that youth are different. The Supreme Court has said over and over again in 4 different rulings in the last 12 years that reiterate this idea that young people are different. And because of that, we need to treat them different. And because of that situation, that their brains are still developing, that the system should be about rehabilitation, let's think about that on the front end of the system so that when a young person is going through thinking about whether they should end up with a record that could potentially be harmful for the rest of their life. Not only are there court records, but there's also police records. And I do want to mention, if you guys happen to have any questions, feel free to type them in the chat area. And as we go along, we can definitely try to address those there. Police records are also generally available. People can get access to those records. Now, the Department of Motor Vehicles, these records can also be used against a young person, in such as maybe the young person's license was suspended for whatever their situation was that they got involved with the court system, and they might want to get their license renewed, or they might need to get insurance later on in life, and it could become a problem then. So insurance companies might be able to find out about the juvenile adjudication, or even employers for jobs that need to look up your driving record. And if at all possible, if you can hear me, could you please mute your phone? I'm getting a little bit of feedback on this end. And then there's also DNA and fingerprint records. Sometimes we don't think about these as being records, but they are out there. In general, the DNA records for juvenile matters in Nebraska are kept fairly confidential, but fingerprints are a way that information can get out there, that a young person's fingerprints can be shared with the state, and then there's a possibility that they could also go into the FBI database. And not even sealing can affect what happens on the federal level. Once the federal government has that information, it's there no matter what we do on the state level. So as I mentioned earlier, a huge problem for young people, because juvenile records are open to the public, is employment. Employers can run background checks, and a young person can be denied employment. The background checks generally don't distinguish between an adult record and a juvenile record, an adult conviction versus juvenile adjudication. Most employers aren't doing the math to verify, oh, this was something as a young person that occurred, or that this was something that they should even take into consideration. It will show up, and a young person generally will have to explain what happened. And, you know, even dismissed cases show up. It doesn't have to be something where the young person was actually adjudicated. Once something's been filed in court, it is a court record, and it is going to be something that shows up unless it gets sealed. And we'll go into the sealing aspect in a little bit. So as I also mentioned earlier, that driver's license suspension can occur because of a juvenile record, a young person getting adjudicated, and that can also affect employment. When the young person's, many young people's jobs will require them to have to drive, and if their license is suspended, then that will end up them needing to have to figure out a way to get it unsuspended so that they can get employment and move on with their lives. And then there's also professional occupation license exclusion, that EMT, people who are working with the sick, the elderly, or children, then they oftentimes have to get special licenses from the state, and the state will look at the juvenile records and figure out whether or not that person should receive the license. And in Nebraska, that is a real situation where many young people have been denied these professional licenses because of their juvenile adjudication.
Yes, it's really important to understand that even a sealed juvenile record can be seen by when a youth is trying to get a license. So the state, if they're trying to work for the state, if they need a license from the state is going to have access to even the sealed records, and that can even affect their ability to get a job. I've worked with a few clients of mine who have gone through SCC or Metro and wanted to become an EMT or wanted to get their CNA license and go into the healthcare field, which is a pretty booming area where jobs are available and are needed. But it's not until after they actually complete their education, paid for their education, that they find out that they will not get their license due to a sealed or an unsealed juvenile record. It's really unfortunate that they have to go through all the schooling first and spend their time in school and their money and their time, and then find out in the end that they will not be able to use their degree that they just learned. We have a question. Can a parent that has had their parental rights terminated get a license to be an EMT?
Well, that is definitely a different area of law than what we work in. So we work with juvenile delinquency matters. I guess that a parental rights termination would probably, I don't know, are those records open to the public? So I don't know that we can answer that on this one. It's a little outside of our purview as we are focusing on juvenile delinquency matters here. So there's also collateral consequences related to education. And we all know that education is a huge aspect of a young person's life. that, about 8 hours every day, the young person is going to class, hopefully, and that takes up, a huge part of the young person's growing up, their education, their ability to thrive in life, and move on and do things with their life. And so if we disrupt the person's education, that can become a big problem. So when a young person's involved in the juvenile court system, sometimes they are having issues with re-entering their local school. There are schools that have excluded young people from being able to return to school after they've been adjudicated, after they are coming back from a placement. I can tell you that we've had a fellow in our program that, several fellows in our program that focus on this because many of their local schools are just denying the young people the opportunity to return to school. And these are young people who most of the time returning to school and going to school on a regular basis is part of their probation requirements. And so it's becoming a frustration to what the young person's supposed to do, in addition to giving the young person just that opportunity to get back into regular life and to get a quality education. So one young person that that one of our fellows has worked with was released from a facility in January and told to return to school in August. This person was 16 years old, and I just have to ask you all to think, what would a 16-year-old do between January and August to keep themselves out of trouble? Are people going to hire this young person? Are people going to do something with this young person to keep them busy and keep them focused and helping them proceed and move on with life and make something? And yet the school could have allowed the young person to go back. It just was not something that they were ready to do. So anyway, our fellow got involved and was able to get the child re-enrolled into school. But it's becoming such a problem that we're expecting these young people to rehabilitate, move on, and do something great, but yet we're putting up these barriers to their success. There's credit transfer from a juvenile facility to local school. There's problems with this because sometimes the young person might be in a placement for 3 months, not quite a full semester, but then their credits, or they don't get credit at their local school when they return back. And then the young person is penalized by having to go into a younger grade, going to classes with youth that are younger than them. This young person has already been dealt a bunch of blows, and now we're telling them that they need to go to class with those who are younger, and that's oftentimes defeating their self-esteem, requiring them to do such. These young people oftentimes face school discipline in addition to their juvenile court involvement. So to give you some examples, there's young people who have gotten in some sort of court involvement that has nothing to do with school, but because they were arrested or because they were placed on probation or whatever, the school was notified, and now the school knows. Many times we have seen that oftentimes will end up with the young person being identified as a troublemaker, and now they are being targeted for school discipline. We also see that young people who are involved in the juvenile justice system, there's a disproportionate amount of young people that need special education services but are not receiving them. And it's the school's obligation under federal law to look into whether a young person needs special education services, and many of the times they just don't do that. The families don't understand whose obligation what is. They don't understand what their rights are. And so there's no one there advocating and understanding this problem. And a young person with school discipline or special education issues doesn't have a constitutional right to a lawyer or an advocate. They could have one, but one is not being provided to them. And so therefore, many people are having to go through this process all by themselves. So if a young person is needing special education but not getting it, they could be acting out in their classes. There could be other reasons why they're then being kicked out of school that is actually just a manifestation of their of the fact that they need some special education services provided to them. Then there's also young people who are missing many days of school. This is becoming a problem when they're having to go to many days at court, then they go to a placement, then they end up having to miss school so that they can go meet with the probation officer or whatever the other requirements are that ends up causing more hurdles for a young person in their education.
Yeah, I will just add that in our state, Nebraska, there's not very many attorneys that are doing student representation and helping youth with their special education or representing them in school disciplinary hearings. I have done a couple of these hearings and advocacy with special education matters, and it's a great need. We definitely need more attorneys doing this type of work for our young people. There's usually an issue with transition. So when a kid is returning from an out-of-home placement and going back into school, it's really important to make sure that if they have special education services, that meetings are set up right away so that their IEP or their 504 plan can continue, that evaluations are updated, that reevaluations are completed. I had one client that I'm thinking of right now who is 17 years old. When I met him, he had not been reevaluated since he was 8 years old. He qualified for special education when he was 8. He had an intellectual disability and some behavioral issues, but has repeated school suspensions, been kicked out of school several times, but just never really got the resources that he really needed, which is really unfortunate because the school is obligated to provide these services and not just continue to push these kids out into the juvenile justice system. And we have a question. Is there any data on the frequency that denial of return to school is occurring? Any data on the differences in discipline rates for those in juvenile justice versus general population?
So the new federal legislation that was passed, the ESEA version, I forget what they call the newest version of it, but it does require schools to gather and report more data than they used to. So they didn't have the requirement to report data on their process for returning young people from juvenile justice placements, but now they do under this new law. They also every school district is required to have a reentry plan for young people who have been in placement, whether it's through the juvenile court system or whether it's through the foster care system. And so everybody should, if this is an area you're interested in, go find out from your school district, what is your plan? They had to report it to the federal government and hold their feet to the fire about what this plan is. Most of them will want to say that this is their plan, but what ends up happening in many ways is that it's much harder for young people. They don't get back into school quicker. They are oftentimes facing these hurdles. You know, the school's telling them, just come back in August, go find something to do for 8 months. But now the state law, or now the federal law is requiring states to keep this data. So we hope to have some information in 2018 about how fast are young people getting back into school, what are we doing with young people coming back from the juvenile justice system, and things in those sorts. Now, the Department of Education does have a lot of data on their website about who is being expelled from school based upon race and based upon special education needs and gender. So please definitely look up on their website some of that information to get their data. We also have a question of at what point is the school held accountable for not assessing and providing the needs of these students? Because no one's doing this advocacy work, or very few people, the need is so high and there are very few advocates out there who are doing the work. Because there's not a constitutional right to a lawyer, only people who have money to pay one generally get to have their young person advocated for. And so many young people are going through these problems without much on the other side. So the schools were required to come up with these plans, but without advocates to hold their feet to the fire to do according to what their plan is saying. And if they don't, you could potentially file a due process claim, just a little side note. But, you know, I think that there are many avenues that schools are getting around. And I'm not saying every school is doing this, but in our experience, many schools are. So many of the younger people these days, not when I was applying for college, but young people these days have to generally fill out the common application for college. It is generally accepted by 600 colleges, over 600 colleges and universities throughout the country, so it's considered you do this one application and all these colleges will accept it versus having to do numerous applications for various colleges. Now, they have a question on their application, and it is quite intriguing. Have you ever been adjudicated guilty or convicted of a misdemeanor or felony? Stop right there. So, adjudicated guilty or convicted of a misdemeanor or felony. We generally don't use those terms in juvenile court, right? So you would think the answer would be no. However, there is explanatory material on the application that says adjudicated guilty means the same thing as a juvenile adjudication. So yes, this question is ultimately trying to ask about juvenile adjudications. It goes on to say, note that you are not required to answer yes to this question or provide an explanation if the criminal adjudication or conviction has been expunged, sealed, annulled, pardoned, destroyed, erased, impounded, or otherwise required by law or ordered by court to be kept confidential. So here in Nebraska, the juvenile records are not ordered or by law or ordered by the court to generally be kept confidential unless they've been sealed. So a young person in Nebraska is going to have to answer yes to this question. So these colleges are asking for information about juvenile adjudications. Now, a young person with a juvenile adjudication in Maryland would not have to answer yes because their records are considered confidential by law. So young people in Nebraska have that extra strike against them as they're applying for colleges when it comes to the Common App. So for housing, there is issues with denial of housing that generally can come because of a juvenile record being available to the public. Landlords can do background checks and get this information and use it in their consideration of whether to deny a young person. There's also public housing issues, so federal regulations that are applicable here because there are two areas in which the federal government says that if you have a conviction or an adjudication in either one of these areas, that you will be denied public housing. Those two areas are, number one, lifetime sex offender registry. Well, thank goodness for Nebraska that doesn't happen here. So that won't be an issue for young people here in Nebraska. However, the second one is that if you were cooking meth or had been with someone and jointly adjudicated of cooking meth on public housing grounds, then you can be denied federal housing. But in general, that's not most young people, right? The issue comes in the state and local regulations. And Ari has done some research on what they require for the public housing locally.
Yeah, so I have the Lincoln Housing Authority application, and there's a question that asks, are you or any other household member or current user been arrested, ticketed, charged, or convicted of possession, using, dealing, or manufacturing a controlled substance? It goes into other things about any household member been convicted of methamphetamine production, and there's additional questions on any household member being arrested, charged, ticketed, or convicted of any of the following, and they list things like drug-related activity, alcohol-related activity, battery assault, sexual assault, burglaries, arson, disturbing the peace, and there's a blank for other. So the local regulations, at least in Lincoln, are way more expensive and invasive than on the federal level. We've even seen some parents who have lost housing because their kids have been charged, have been adjudicated delinquent or even arrested. They don't even have to be adjudicated. They're just looking at even arrest or a ticket. So they don't even have to even have a conviction on their record. It's just a matter of if Lincoln Housing Authority finds out about it.
And disorderly conduct is one of those catch-all, basically anybody can get that for almost anything kind of charge. So that being on there means that it's going to include a lot of things. There's also the denial, or outside of the denial of housing, there's also the eviction. So as already mentioned, that once a young person's landlord finds out about a juvenile adjudication, even the arrest, they can be evicted from their housing, especially dependent upon a leasing agreement. But when the lease becomes up for renewal, they can be denied renewal for general reasons such as a juvenile adjudication. Another thing that we have seen a lot and more of is homelessness amongst young people who have been through the juvenile justice system. There is sometimes where a young person is being released from a placement directly into homelessness. For example, that was basically the reentry plan for a young person where the probation officer took the young person from their placement directly to the homeless shelter and dropped them off. That wasn't much of a reentry plan in my opinion, but that is what they found for the young person, where the young person could stay. And homelessness is not just a young person sleeping on the street or in a shelter. Many young people these days are couch surfing, either on their own or with their families. Housing can be crazy expensive and very limited. Affordable housing is hard to find. And when people are doubled up, tripled up in houses where their names aren't on the lease, at any moment they could be evicted and have to find some other place to go. And when I say evicted in that sense, I don't necessarily mean by the landlord. I mean whoever's name is on the lease gets to decide who's staying with them and who's not. So what a young person's having unstable housing is a huge problem for young people who have been in the juvenile court system, that we have to, as advocates and as court personnel and other people who are involved with this system, recognize this and help young people access the services that they need. There's sometimes legal services that they might need and social services that they need to avoid homelessness or to get out of homelessness.
Can I add something real quick?
Yeah.
And so most of you, probably all of you know that in Nebraska we have the Bridge to Independence, which if the kid is on the foster child welfare side, they are able to get a housing stipend, which can provide for housing, affordable housing for youth. But if a kid is strictly on the juvenile justice side, they don't have access to that program and those resources. So a lot of kids who are not dual status, who are strictly on the juvenile justice side, don't have those resources, which is unfortunate.
There are states that have been able to tie those together, where a young person who's been through the juvenile justice system can get a foster care placement and become eligible for extended foster care to get help with housing and other independent living services as they are becoming legal adults. And we have seen how that's worked fairly well in the case of some young people. Is there data on the number of juveniles in Nebraska who aged out of the juvenile justice system that are currently homeless? Any sites we can access that provide data on future outcomes for youth involved in the juvenile justice system? So there is numbers that are taken every year. It's a day, I forget what we call it, the day in a day count, something like that, I can't remember. But it's done in most cities, and I believe Omaha does it. I'm not sure if Lincoln does it. But they count the specific young people who fall underneath the definition of homelessness, and that that is available online. What I will do is, I can't remember the website that it is on, but I will look that up and I will make sure to share that with folks. But that information is available, but it doesn't divide up who is involved in the juvenile justice system. So there's a national survey of young people, and I think it's 40 to 50% of the young people who are homeless that have indicated that they have been involved in the juvenile justice system. Those who are homeless identify as 80 to 90% of having some interaction with the justice system. It's a really high percentage because it's either caught a young person on the front end or the back end of the system. So what I mean by that is that some young people who are homeless end up with adjudications or adult convictions because of their homelessness. They don't have anywhere else to sleep. They needed to have food. They participated in particular activities as survival, as a way to survive. So that's one way that they could have been homeless first and then gotten involved in the justice system. And then, as we've been talking about on the back end of the system, that sometimes they are released into homelessness. Sometimes we have the plan that they're going to go stay with grandma when they're released, and then there's no one checking up, you know, the next month or two. And now that young person's been kicked out of grandma's house, and where are they supposed to go? Or, you know, mom's boyfriend is at that house, and mom's boyfriend beats the child, and they don't want to stay there anymore, so they leave. Most of the time with homelessness, we hear the word runaway, and people are thinking, oh, that means that kid is bad. But most of the time the kid is running away from something. There's something that's going on in that household that makes the child unsafe and feels unstable in that place. I can't tell you how many young people I've heard some heart-wrenching stories about how they ended up homeless. And half the time it's because they were kicked out, but the other half of the time it's because of what was going on in that household, something that none of us would ever want to. Somebody hit mute on your phone. Thank you. But yes, thank you so much for bringing up that question, Jason. I think that there's definitely more research that could be done around this issue, and it would be great if there would be state-specific information that's done, state-specific research that's done, so that we know more about the effects and how young people are ending up as homeless. So there are many other ways in which a juvenile record can affect a young person's life. There are sentencing enhancements where the court can look at the young person's record and take that in consideration when the young person may get involved with the criminal justice system involved as an adult. There's also fees, fines, and restitution. This young person in their juvenile case might be required to pay a certain amount of fees or restitution, and if they don't pay that, what's going to happen? Sometimes that stuff shows up on a credit report, and when employers or landlords do credit checks, it could come up as a strike against the young person that they have this unpaid amount out there. And I've seen youth who have had thousands of dollars listed in their restitution requirement. It is insane to think that $20,000 restitution for a 16-year-old is somehow a good idea. I don't need for an adult, like I don't even know how I would even start, and I have, you know, a fairly decent paying job, but how would I go about paying that in any reasonable amount of time, let alone a young person being able to pay that amount during their probation. So that can be an issue or a problem for youth. There's also immigration. This is a really big issue, especially with what's going on in our country right now, but adjudications can be a mark against a young person if they're applying for citizenship. It is an issue that we need to be aware of on the front end of the system, that before a young person gets an adjudication, before involved with the courts, that they understand that there could be some immigration consequences to an adjudication. And a young person could be denied ability to stay in the United States. They could be deported because of their juvenile court involvement.
In addition, there's the central registry issue. While we don't have sex offender registry for young people, sometimes they can be placed on DHHS's central registry if they have committed some type of abuse on a younger peer or a younger child. So it's important to check if a kid has successfully completed probation and they were adjudicated of let's say a sexual assault, and they've done all the therapy and they completed everything successfully. It's important not only to check and see if they have been placed on the central registry, because that is an additional way that that the public and future employers can have access to information about that adjudication. So what I usually do, if I'm able to get a juvenile record sealed for this type of offense, I also will contact DHHS and check to see if they are placed on the central registry and go through that expungement process. So it's just an additional thing to think about, additional way that people can have access to this type of information.
So I just wanted to note, I did a quick search, Google search. It's called a point-in-time count to learn about homelessness. When you want to look at those numbers, it's actually something that's kept through HUD. If you want to check it out on their website, that they keep the records of the point-in-time count of youth homelessness. So we've come up to so many barriers, described so many problems and issues with juvenile adjudications. And we just didn't want to leave it there, though, because there are some things that youth can do and that advocates can do and court personnel can do to help a young person overcome some of these barriers.
So there are 3 ways that a juvenile record can be sealed, and the first 2 ways are if charges are not filed or if the case is dismissed. Now, typically what's supposed to happen is the sealing statutes say that if this is the case, so the prosecutor decided not to file charges at all, in that case you're sealing police records, you're not really sealing a court case because there is no court case. But if a court case is filed, but then it's ultimately dismissed because of pretrial diversion or something like that, or if there just wasn't enough evidence to prosecute, to adjudicate the youth and it's dismissed, then those cases should be sealed automatically. The youth should not have to petition to seal. We were finding this was not always happening, especially with the dismissed cases. After the kid has done everything they're supposed to do, if they had to do pretrial diversion and they successfully completed it, that's when the case should be automatically sealed. The court should be sealing those. But for some reason, we weren't noticing that. So it's always good just to double check on justice to see if those dismissed records are sealed.
And if they're not automatically sealed, you can file a petition to ask the court to do such. And if it's become a problem in your jurisdiction, Ari has worked with the prosecutors and the judges to try to bring this issue to attention in Lancaster County so that they can fix the problem. So if there are other jurisdictions that are not following this regularly, please do what you can to try to bring the issue to people's attention. You can also file individual petitions in cases too.
The most common way that juvenile records are sealed is after a youth successfully completes probation, mediation, or whatever else the court has ordered them to do. There is a distinction, though, on when it starts. And so the statutes say that if the youth is 17 years old or older, when their case closes successfully, then the courts are supposed to automatically initiate the sealing process. That doesn't mean that the record is automatically sealed, but just that the process has automatically started. If the youth is younger than 17 when their case closes successfully, then they have to petition on their own to get their record sealed. Sometimes if their case is a little bit older, I think the most recent sealing statute was amended in 2011, so if their case is a little bit earlier than that, most likely they're just going to have to petition the courts to seal. And typically, after a youth has filed a petition to seal, the court will file a notice of intent to seal, and then that gives the prosecutor 30 days to respond whether or not they agree or disagree with, or whether or not they agree or object to the sealing. If they don't respond within 30 days, or if they say basically I'm okay with this getting sealed, then the judge can seal the case without having a hearing, or they can decide to have a hearing anyway. If the prosecutor objects, then there's going to be a hearing where the youth is going to have to put on evidence to persuade the judge that they have been successfully rehabilitated. Usually I see prosecutors objecting to sealing based off of the nature of offense, if it's a serious offense. I'm seeing objections if a youth has newer adult criminal convictions on their record.
And sometimes not even criminal convictions, right? Traffic?
Yeah, I've seen some traffic. Unfortunately, I had one youth who had a couple speeding tickets and I think something like driving without insurance. And they paid the fine. They did everything they're supposed to do. Their traffic stuff was not even related to what they were put on probation for as a youth. But yeah, the prosecutor objected, even though they successfully completed probation and they did everything that the court ordered them to do. So it's really important to try to get these sealed right away, right when the cases end, so that this isn't an issue going forward. Yeah.
So what is the effect of sealing? And you guys all seem to get the point of this earlier when we did our poll, but it just hides the record from the public. It doesn't actually delete it. There are still people who can see sealed records, such as the court and the state employees and law enforcement. But the youth will not need to disclose their sealed juvenile record on most employment or housing applications, which is so important. Once it's been sealed, it's no longer going to come up on a background check. At least it shouldn't. The Federal Credit Reporting Act requires that all of these background check agencies keep their records updated, and so therefore they should not be releasing information about sealed records. However, we all know that sometimes things happen that shouldn't happen. But if that's the case, then what we need to also make sure is that that agency, whoever's doing that background check, understands that they just violated the law and they shared something that was sealed and that they shouldn't have shared. I know one thing that if that happens on a regular basis, that I've met with several private attorneys who would love to bring this issue to court and challenge their practices on that, because it ends up causing so much harm to people who may have otherwise passed every other requirement to get the job, but this thing shows up on their background check when it was sealed and shouldn't have shown up in the first place. Then we wanted to talk a little bit with you guys about how young people might be able to properly answer questions about their juvenile record. Generally, you'll see questions on applications that say, have you ever been convicted of a crime? So this answer, if they only have a juvenile adjudication, would be no. Most young people don't understand that there is a difference between adjudications and convictions, so they're self-disclosing at this point, even though that's not the question. Now, the issue in Nebraska is that the juvenile adjudication will show up on a background check, and most employers aren't doing the research or understanding to know that what they're looking at is a juvenile record, or they also don't understand that that is not actually a conviction by Nebraska statute. So it's a little tricky, because what if a young person answers no and then their juvenile adjudication shows up on this background check? Under the Federal Credit Reporting Act, they are required, they being employers, are required to disclose to the young person the record in which they received, and are required to give them the opportunity, give the youth the opportunity to explain. And so if an employer did a background check and it shows a juvenile adjudication and the young person said no to this question, they're supposed to give the young person the opportunity to see what the background check said and then to explain. And though that can oftentimes be a runaround, maybe that could be an opportunity for the young person to help the employer understand that the question asked about convictions and what they're looking at is a juvenile adjudication. But it could still, because juvenile adjudications are available to the public, be a strike against the young person. You also might see questions about whether they're convicted of a felony or a misdemeanor. And then there's questions about, have you ever been arrested? Like Ari was mentioning earlier on the housing application, that is a big issue. That even without the adjudication, that they're being asked about being arrested. And that becomes a problem that young people are facing. And have you ever been on probation? These are questions that we've seen on other housing applications also, that even though it is a juvenile matter, it's still called probation, and a young person might have to disclose their juvenile adjudication. So what tips do we have? What should a young person say when they have to talk about their juvenile record? Here's some things that we like to tell our clients, is that they just need to be aware that since juvenile records are available to the public, many employers and landlords may not understand that what they're seeing on their background check is charges on a record are actually juvenile charges, not adult charges. So this is what I was talking about earlier, that it becomes an issue. But they need to emphasize how they've made better choices since their involvement with the juvenile court system and focus on their positive qualities. The worst thing we can do is start making excuses. If the young person needs to explain, the best thing is to be very brief with few details and avoid blaming others. So by very brief, here's an example. In 2015, I had a misdemeanor. That I was on probation for 6 months that I successfully completed, and I've not had problems with the court since. Something like that would be very brief. It's many times a young person, when being asked, might want to go into detail. Well, Johnny and I decided we want to hang out that day, and we went into the store, and he thought it would be a good idea to take this stuff. I didn't have anything to do with it, but somehow I got dragged into it. Things like that ends up going bad for the young person. The employer is oftentimes going to see that as the young person not taking responsibility for their actions, no matter what may or may not have happened at that time. Maybe it really wasn't them, but they need to just not include that in their conversation with this potential employer. This is not the time to argue about whether they should or should not have had an adjudication. It's just the time to say what is and move on. So very brief description. And sometimes it's hard to talk about past events. So we advise young people to practice with a friend or a mentor to make sure that they feel comfortable with that conversation. I can tell you that many times I have talked with folks before going into court, and then when they get on the stand at court, they start telling these 10-minute long stories after we just had a conversation about the fact that it needed to be short and quick. And you know, that when you get in the moment, sometimes they like to go on and on. So the more that they practice, the less likely they will do that. The more that they practice, they'll figure out how, and they'll get comfortable with keeping it short, with avoid blaming others, concentrating on how they've made better choices and what their positive qualities are. Another great thing that we suggest is getting a letter of recommendation. This letter of recommendation can be from someone who can assure the employer or the college that you are a good candidate, that the young person will do a good job. So this is not just something that says, you know, I know who this young person is and they're great. But what we suggest is that the young person have had experience with volunteering somewhere for at least 3 weeks and try to do 20 hours a week if at all possible, so that they show that they are responsible, that they show up to the job site when they're supposed to, that they stay for the period that they're supposed to, that they're respectful and they do what they're asked to do, and that they're not calling out all the time and saying, oh, I just can't make it today. Because these are the things that employers are facing a lot of times with young people, is that they've not quite learned the skill of how important it is to make sure that you go to work on time. that you stay the entire time you're supposed to be there, that you're not talking on your cell phone the whole time. And if there can be a letter of recommendation up front that says this person has shown me that they can show up on time, that they're responsible, that they're respectful, that they do what they're being asked to do, and I don't have to get after them for everything, that is really helpful for that young person, especially when they have a strike showing up in their background check with a juvenile adjudication. So we are greatly appreciative of you all participating with us today. If you have any questions, feel free to include them in the chat box. This is also our contact information, so you can feel free to contact us. The National Juvenile Offender Center and Legal Aid of Nebraska have joined to create a booklet about the collateral consequences of a juvenile adjudication in Nebraska. We are working on some final edits for that, and what we will do is get this information out to everyone who has participated in today's webinar. We'll get your email and send you a copy. We are really looking forward to hearing from you all any feedback you might have, and we can send you physical copies because we're going to have them printed. So please, once we email you the electronic copy, please let us know if you'd like to have any printed sent to you. And please include your mailing address if that's the case. But we are available for any questions if anybody has any. Well, maybe we were extremely clear. We're grateful that you guys are thinking about these issues because most folks don't understand that young people are facing consequences because of their juvenile record. They think, oh, it's just juvenile court. It's not a big deal. There's nothing that's going to happen. Well, as you can see, there's a lot of them. And we can really help young people try to avoid having these consequences by avoid getting a juvenile record in the first place. But then on the other side of it, that if they already have a juvenile record, we can help them overcome some of these problems. So we greatly appreciate the fact that you have participated today, and we look forward to providing you the booklet on collateral consequences of juvenile adjudications in Nebraska, and look forward to communicating with you more as if you have any questions for us.
Looks like we have one question. Are there consequences when a juvenile has a 3B filing against them? I usually don't see like a truancy really preventing a youth from like getting a job. I'm not even sure if the truancies will show up on a background check, but those you can still get 3B filings sealed as well.
I believe they do show up on the background check.
Okay.
I don't know whether how the employers will take that into consideration or anything. But yeah, that would be a great thing to make sure that gets sealed, because the less stuff that shows up, the better for the young person.
Would it be appropriate to have some of these pamphlets at the schools?
I definitely think that that is a good possibility. We would not be sending them to the schools because we don't have relationships. Generally, what we found out is that if we send materials someplace without having any relationship or any introduction, people just kind of put them in a box on the side and don't really utilize them. But if you all have relationships with school counselors or even school resource officers or other people that you could share this with, please let us know and we can send you many copies so that you can share it with them. We just don't want to send things without having kind of that relationship to build upon. Otherwise, we'll have just resources sitting in the corner of someone's office somewhere.
And then Teresa wants to know, are there criminogenic hours being offered?
And we will follow up with that, Teresa.
Is it similar to print the certificate of attendance?
And when we will be sending out an email with the link for the webinar to our YouTube page, and then also send a certificate of attendance.
Well, we would love that you guys share this with your CASA volunteers, because I know that there are many crossover youth who are in both the juvenile justice and foster care system. So the more people that know, the better. Thank you all so much for participating. Again, our contact information is on this slide, so feel free to reach out to us.
Thank you all again. And like I said, we'll have the webinar on our website and our YouTube channel. And please let us know if you have other questions. Thank you, Serena and Ari, for participating and presenting.